We are back with a fresh bad faith. We have returning to the podcast, Professor Jed Shugerman, who is a professor at Fordham Law School, visiting professor at BU, and soon to be permanent professor at BU Law School. Welcome back to the podcast, Professor Shugerman.
Thank you for having me back. Thank you.
It's such a pleasure. And new to the pod for the first time, Persis, who is Deputy Executive Director of the Student Borrower Protection Center, one of the foremost experts on today's subject, student debt cancellation. Welcome to the podcast, Persis.
Thank you. It's great to be here.
All right. So obviously we're talking today because yesterday we listened to oral arguments on the Supreme Court about the viability of Joe Biden's student debt cancellation plan. Jed, last time you were on the podcast, we talked about what we perceived to be vulnerabilities in the approach that Joe Biden had taken, namely the choice to use the HEROES Act as opposed to the Higher Education Act as the legal authority to hook the executive power under which he is canceling this student debt. And whether or not I was arguing or contemplating whether that was a political choice, how invested Joe Biden really was in this, and what the likelihood of it actually overcoming challenges that we only anticipated at the time actually was. And so I want to ask you first, is this playing out as you anticipated? And if not, how is it departing from what you expected?
Yeah, that's a great setup. And I think it's really important that you talked about that we keep the focus on the Higher Education Act of 1965, which is complicated, but it is the other path forward. And unfortunately, what's also played out is that other path, instead of taking that path by taking this path under the HEROES Act, whatever time was available to use the longer process for the Higher Education Act, that time is even less and is gone, right? There is no way back if the Roberts Court strikes down this program.
Why is that?
Because Biden would have, there's a way back only if Biden wins in 2024.
I see.
Because of the timeline. Even though there is a 18 months, what is it? It's about, even if there is almost, about 20 months left in this administration, it takes a year. So you stop me if I promise I can come back to this, but basically, and we can also talk about why this is also Bill Clinton's fault and Barack Obama's fault, to be honest with you.
I know
you're here for that. But there's a lot of there's a lot of Wall Street Democrats who've made this whole process more difficult. So, but if we will circle back to that, but if the Roberts Court strikes this down, which seems more likely than not, although there are some wrinkles on standing, if it gets struck down in June, then the Biden administration would have to start over either with, and probably with the Higher Education Act of 1965. That would take a year to at least rescind the Obama era regulations that make it hard to do anything like this. Adopt new regulations a year from now. And then as soon as that program is announced, of course, then the conservatives would run to the next district court and have arguments about why there should be a nationwide injunction. And then that would take up the rest of the time through the election.
So, Jed, let's get into this, though. My understanding was that, frankly, the questioning on standing gave people who might otherwise have been kind of afraid about how the court was going to rule on this one from the perspective of someone who wants student debt cancellation to happen.
Right.
Was somewhat reassuring, including because some of the conservative justices, I believe Amy Coney Barrett, was also seemingly preoccupied by these standing concerns. Is that not giving you optimism or a glimmer of hope? Or
well, I mean, let me say, first of all, you got to keep the big picture in mind. If they start, first of all, on standing, I spent 4 years of the Trump administration litigating and writing amicus briefs on the emoluments cases challenging Trump corruption. And we depended upon having a capacious, flexible, broad understanding of standing for the rule of law. So I'm not eager. I mean, you win the battle, but you lose the war here. If suddenly the Roberts Court is saying, oh, yeah, there's no standing to enforce the Constitution, be careful what you wish for, number one. Okay.
All right.
Okay. And so other examples came up in court about, other examples came up yesterday about the importance of having broad standing. When the Trump administration tried to put the citizenship question on the census, it was a very indirect claim of New York to be able to challenge a racist partisan policy of the Trump administration. The Trump versus Hawaii, the Muslim ban, very indirect claim by the state of Hawaii. Very important that they should bring it. Number 3, the rescission of DACA against the Dreamers. By a 5-4 decision, it depended upon the standing of UC Berkeley. Last time I checked, UC Berkeley was not an undocumented immigrant. So it's really important that that standing is not suddenly limited in ways that conservatives find very convenient. All right.
Well, let me interrupt just for a second there and come to Persis, because let me know, is your view that, I don't know how familiar you are, obviously, Jed is saying that he filed amicus briefs and was weighing in on those particular cases, and I'm not sure how familiar you are with the actual standing issues that were in each of those. But does it strike you as a close standing case? Does if the court were to not find standing in this instance, do you think it is right to say that we should be concerned about how this might limit other opportunities for relief that as progressives we might be favorable of?
Yeah, I mean, so I think it is standing. I mean, so first of all, I agree that, like, I think, standing is, of course, the threshold question, and they have to reach a decision on standing in order to even get to the question of the HEROES Act, which I, of course, think is a legitimate use of the Secretary's authority here. But I think it's actually really interesting when you think about standing and the conservative perspective, because a lot of the case law on standing is actually been developed by conservatives to limit the ability of consumers to use the courts. And actually, this is something that's been very frustrating for me from the beginning, is that this body of case law that has, we're talking about Ramirez versus TransUnion, which is a case about, the use of being on a credit reporting agency putting people on the terrorist watch list, right? Or Spokio, which is about this company that was like selling junk information to employers, and how those consumers in that case did not have standing. And certainly I think, I guess what I'd say is, I think at least if nothing else, this is a conservative standpoint on standing, and it should at least be applied evenly, right? Like, if you apply the standard that has been applied to consumers over the past decade, then you should not find that these folks have standing. And so I think that there are many cases in which I wish personally that the standing, that the standard for standing were different. But I think as it is, if you apply the law as it exists and as they are, and frankly, like, if these student loan borrowers were to sue their servicers, right? Like, this is the standard that would be used and held against the consumers. So I think if you apply that standard equally, you're going to find that these plaintiffs don't have standing.
I'm not sure about that. So first of all, I think there was only one conservative who really sounded like, it was only Amy Coney Barrett. I mean, to the extent that when you're trying to read tea leaves, when you try and figure out, like, is it justice asking both sides questions in the same tone and not just in a rhetorical way, but asking good faith. I know this podcast is called Bad Faith, right? There are questions asked in bad faith, or there are questions that are asked rhetorically. Amy Coney Barrett was the only justice who was asking those kinds of questions to both sides in that same tone.
General, I'm thinking of an Arkansas versus Texas. It was significant in that case that Arkansas owned the land of the university. So it does seem that Missouri has created the separateness with respect to the liabilities of Mohela. What if, and I'll ask this to the other side, it's not really clear to me what happens to Mohela's assets. I mean, what if Mohela itself dissolves? There are no shareholders. I mean, does your answer change if, even though Missouri is not responsible for the liabilities, it does have an ownership stake in the assets of Mohela?
I think it's clear under state law, Justice Barrett, that Missouri doesn't have that kind of ownership interest in the assets of Mohela. And I would point in particular to Missouri Revised Statute 173.410. This is the provision that makes clear that Missouri cannot take the assets of Mohela and appropriate them. They don't go into the general treasury. It makes clear instead that those assets are under Mohela's exclusive control. So I think as a matter of state law here, we don't have anything like the Arkansas case that you just referenced. And as well, the flip side of that is the provision of state law that likewise says Missouri is not going to be liable for any agreements or obligations or liability of Mohela, so that if Mohela goes out there in the world and harms someone, the state's not on the hook for the damage. And that's another distinction from the Arkansas case, where under state law there, it was clear that a suit against the instrumentality was a suit against the state itself.
Would you have the same position with respect to federal corporations? Like, what about the FDIC or organizations like that? What if the agency didn't want to sue? Could the United States sue to protect the federal government's interests if the corporate identity was separate, like here?
No, I think that our principles would apply with respect to our own instrumentalities. We could, of course, sue to protect distinct rights and interests of the United States. And so respondents have cited some cases, for example, where an instrumentality entered into a contract on behalf of the United States in the name of the United States as its agent, and we had a contract right that we could enforce in our own name. Or there was another case that involved a statutory right in the tax context to offset, and the United States was permitted to sue on that basis because it had its own rights and interests. But we've never done what the states are doing here, and in the absence of any underlying contract right or statutory right or trust right, just asserted this all-purpose ability to blur the distinction between the sovereign and instrumentalities when they're separately incorporated in this way.
Roberts and Kavanaugh were asking those questions too, but they were so much more focused on the merits. So, and also let me say, in terms of what the facts look like. I mean, Solicitor General Elizabeth Prelogar was outstanding. It was one of the best performances I've ever
She
heard.
was phenomenal.
COVID-19 is the most devastating pandemic in our nation's history, and it has caused enormous disruption and economic distress. Over the past 3 years, millions of Americans have struggled to pay rent, utilities, food, and many have been unable to pay their debts. To head off immediate harm for student loan borrowers, 2 secretaries across 2 administrations invoked the HEROES Act to suspend interest and payment obligations for all Americans with federally held loans. But if that forbearance ends without further relief, it's undisputed that defaults and delinquencies will surge above pre-pandemic levels. The states ask this court to deny that vital relief to millions of Americans, but they lack standing to seek that result.
It was phenomenal, and part of why I think people come away thinking that that the Biden administration might win on standing is because she crushed. I mean, I think that I think the Solicitor General from Nebraska is still like a puddle somewhere in the Supreme Court. He was, first of all, terrible, and it's also pretty remarkable that the only state that has a case for standing is Missouri, and that Solicitor General just happened to not be available to ask the question. It was the optics yesterday were a disaster, but that doesn't mean the underlying facts. If the 5 justices who want to get to the merits, I've read the briefs. I don't understand. The facts seem to be clear enough for this one reason. Okay, so the rules for standing are that you have to have an injury in fact. Number 1. Number 2, it has to be fairly traceable, not direct. There's no directness rule. It's very important that it can be indirect, but it has to be fairly traceable to the policy. And number 3, you have to be asking for relief, which would redress the injury. And at least it seemed clear in the briefs, and it seems like I still think that it seems like even out of the oral arguments that the state of Missouri is on the hook for losses, even if this Mohela independent agency has its own, can sue and be sued. That isn't that big a deal, and even though its budget is separate, at the end of the budget process, Missouri's on the hook for the losses. So that's enough.
I think
take a step back. Wait a minute, guys. Let's take one step back and just Persis, I want to let you in here, but can you start by first just laying out what the standing argument is? Because there's two, right? There's the 2 law students that are claiming, or the student debtors, law students. That's very me projecting. There's 2 student debtors who are claiming that they're injured by this, and there's also these 6 states that we're talking about who are suing kind of proxy through this claim of the student servicer called Mohela. So for those who don't know the facts, what are the facts, Persis?
Okay, so laying out, we'll start with the 2 borrowers, and then I'll move into the state's case, right? But you have these 2 borrowers, one of whom has a commercially held federal family education loans, FFEL loans, and so is not eligible to receive the up to $20,000 of debt cancellation. And then you have another borrower who does have a Department of Education held loan, but didn't receive a Pell Grant when they went to school, and so is only eligible for the $10,000. And
as opposed to the $20,000.
As opposed to the $20,000, correct. And so they are arguing that they're arguing that essentially this is unfair, and that if they had had the opportunity to provide notice and comment, then they would have then commented and then asked to have been given relief. They're complaining essentially that they they didn't qualify and they want to qualify. And I think that's important, again, to talk about the redressability issue that Jed raised. So that's the one case. And so their standing is based upon the fact that they didn't get relief and that they have a procedural claim, or they're trying to make a procedural claim that they're entitled to notice and comment on the policy.
And just the redressability claim, what you're basically saying is, to your point about what the elements of standing are, Jed, if the outcome is in their favor, if the court dismisses the lawsuit and they aren't benefited by it, then there's an argument that they don't have standing, because you're basically trying to prove that you are harmed by this if you're not provided some kind of relief by the outcome of the case going in your way. How is it that you're actually affected?
And I think the Solicitor General did an excellent job of kind of like highlighting, she called it this mismatch between what they are arguing their harm is and what is the relief that they're seeking, right? And so
so to be fair, I mean, there was a lot of what Preligar was really good. She was good in two ways. She was good at highlighting the weakest part of their argument and emphasizing the weakest part. But she was also good at responding to what, and this is, I think, important for lawyers to do. There is a valid argument that they're making. It's a stretch, but it is a valid argument. And it's not that, okay, so you have to assume for standing that they win step one. You have to assume for the sake of argument that what they're saying is that the HEROES Act is not valid. Now, we can always come back to that, but for standing, they'd say, if we assume for the sake of argument that the HEROES Act is not a valid basis for this, then what they were entitled to is that the federal government, Biden administration, would have used the Higher Education Act of 1965. And that is a valid basis. And through that act, there would have been a process of notice and comment that they could have participated in. And their standing is based on the Biden administration depriving them of the appropriate statute and the appropriate statute's process. And that is a coherent claim. It's just that the problem is it's speculative that if the Biden administration couldn't have used the HEROES Act fast process of, boom, 2 months, that the Biden administration would have used the longer process.
So just to break this down just a little bit for people who haven't taken administrative law, including me for 15 years, and I also slept through it because it was an 8 a.m. class.
Oh, wow.
The idea, sorry, Professor Tushnet. The problem is that, there is this opportunity for the public to weigh in called a notice and comment period when some laws are prospectively promulgated. And what they're saying is that because that opportunity is by statute not provided under the HEROES Act, probably because it's an emergency act and you're supposed to act quickly, as opposed to the Higher Education Act, that they were denied that opportunity. My understanding is that the rejoinder to that, the comeback is, well, the point here is that we're supposed to be following what the law says. And so much of what the conservative justices are always upset about is the idea that the court is making law, that people should just legislate things and not try to get it through the courts. That's a lot of the argument. Joe Biden can't get this through legislation, so he's trying to strong arm this through. But the counter argument here is, well, the actual law of the HEROES Act specifically provides for there not to be a notice and comment period for specific reasons that the legislature decided and agreed on. They want this to be an expedited act.
But
I think that's a really important. I think that's a really important point.
Argument.
Go ahead. Go ahead, Persis, real quick. Yeah.
No, here's the thing. I mean, Congress very explicitly said that that it waived the secretary's requirement to use notice and comment, and so very explicitly it said that notice and comment doesn't apply in these cases. And like Jed said, you have to go to a very speculative place to say that if they hadn't done this, then they would have done this other thing under this other law, which then maybe would have required notice and comment. And I don't even know that, I think that there is also there's not consensus on the fact that, and in fact that many people disagree about whether notice and comment would even have been required under the Higher Education Act either. And so I think you reach, you have to take a number of different leaps in order to get to this speculative place where the secretary would have done something different under a different law, possibly using a process that might have conferred them standing. That's how many steps you have to get to for these plaintiffs to get standing in this case.
Jed?
I mean, I think this isn't the stronger argument. It might be helpful for us to agree to disagree. because we're going to get bogged down in something called. But I will just because maybe we should get to Missouri because I think that's the more likely case.
Okay,
all I will say is, but I think it's but I think that the backstory, regardless of the standing argument, it is really important to note that the reason why the Biden administration used the HEROES Act and not the Higher Education Act was to avoid the process required by the Higher Education Act.
I don't know that I agree with that. I don't know that there's consensus on that. I speculate for different reasons. I'm not going to speculate out loud here, but I have a different, I think
behind closed doors, behind closed doors, people will acknowledge.
Well, but that you say that, Jed, like as though it's necessarily nefarious, but you've already laid out the fact that because of that longer time period with the Higher Education Act, that is long in part because of this notice and comment period, that it might get to a place where it ends after Joe Biden's president, right? So there could be reasonable political
or you can also look at it this way. That you can also look at it this way, right? That the reason why Congress waived notice and comment is because it takes a long time, and they want to be able to provide emergency authority, right? So, like even under that reasoning, like it's still coherent that if the purpose was to avoid notice and comment, it's because Congress specifically waived notice and comment because it takes a long period of time, and therefore you're not able to deliver the relief that you need to give to the student loan borrowers.
That begs the question of whether the HEROES Act was an appropriate use of the emergency power under the HEROES Act, which I'm happy to talk about.
So which I think we disagree on as well. So
we're going to get to that, but let's come back to you, Persis, and tackle the second standing argument that's made with this Mohela situation.
With the Mohela case, yes. So in that one, we have six states. 5 of them were AGs, and one was the Solicitor General, who brought a case claiming 3 different theories of harm, right? So you have the first one is, a number of these states, such as Arkansas, and Nebraska, they have fell lenders. And so these lenders have portfolios, and there is an assumption that these portfolios will somehow be harmed because student loan borrowers with the FFEL loans will then be incentivized to consolidate their loans into the direct loan program, and so these lenders will lose volume. So that's one bucket. The administration kind of effectively eliminated this reasoning for standing because, frankly, just right before this case was filed, they had decided that borrowers with commercially held FFEL loans did not qualify for this program.
I'm sorry, are you saying FFEL loans?
FFEL loans, sorry, the federal family education loans, the FFEL loans. So these are the loans that were originated prior to 2010, and they were originated by banks, but they were guaranteed by the federal government.
I see.
And so they're owned by like private or non-federal entities. Some of them are banks, and some of them are these state lending agencies, you have in Arkansas.
So the argument is that to get relief, people are going to have to consolidate these loans, and it's going to take them away from the private lenders, and then therefore the private lenders are going to lose the servicing fees.
That's correct. That's the argument. That was the argument. Yes, and so, so the administration had determined that those loans actually weren't eligible anyways to be consolidated and then eligible for relief, and so that kind of knocked away that lane for standing. The second argument that the states make is that some of these states are going to lose tax revenue because a number of states have their tax codes mirror the federal tax code. Right now, under federal law, student loan cancellation is not taxable, but that law sunsets at the end of 2025. And so these states are saying that because our statute mirrors their statute, that we're going to lose tax revenue in a couple years because we believe that there are going to be some number of borrowers who are going to get cancellation through the other federal student loan programs, and that we would be able to tax them on that. There's a number of different reasons why that. I think that is also incredibly speculative, especially if you look at the success rate of some of these programs and how few borrowers actually get cancellation under them. So I think there's a number of different reasons why that's problematic.
Well, isn't part of that the counter argument to that also that it's kind of a self-harm, and if the states could choose not to mirror their tax policy on the federal tax policy, and you don't get to hurt yourself and then claim relief?
That's exactly right. Yes, that's exactly right. And that was really the point that the Solicitor General made yesterday, was that, look, if you don't like this, you can change your tax code. The state can in fact choose to not mirror the federal tax code, and so this is entirely a self-inflicted harm. I think there's a factual. I mean, I think there's a factual problem with all of these arguments of standing, to be perfectly honest, but we don't have a factual record in this case. So we're left with what people say. And so finally, I think what is really like what has become the central argument is that Mohela, who is also a FFEL lender, but for the most part at this point, they make their money from their federal student loan contract. And so they make their money from the federal student loan contract. The argument is that Mohela, because we see a number of borrowers who are going to see total debt relief, that they are then going to have a diminished portfolio, which means they're going to make less money. And so that's Mohela, right, who is not a party to this case. And then somehow that the state of Missouri is going to lose revenue because of Mohela's harm. So you have a couple of different like leaps that you need to make, because first of all, you have to like make this leap that Mohela actually does lose money, which or that if they were to lose money, that would confer standing on them, which I think for a number of reasons isn't true. And then that any harm that, this company, which is a separate legal entity, can be sued and can sue and be sued in its own name. And it has been set up specifically to insulate the state of Missouri from any financial harm. Then somehow when they lose that money, it means that they won't pay into these other funds, which they haven't been paying into for almost 15 years anyways. And therefore the state of Missouri is going to lose money. So there's a number of different leaps that you have to get to get harm to Missouri from Mohela, but that is the crux of where this case is landing.
I understand why you want to speed past that, because it's very granular and it seems like Byzantine and silly, but I do think it's important to understand exactly what we're talking about here. Mohela, the M in Mohela stands for Missouri something, 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 right? It's a Missouri-based student loan servicer.
Yes, it was created by the Missouri state legislature.
And the idea is that it's incorporated as a separate entity from the state so that it has certain rights and privileges.
Correct.
Right? And the idea is that they're now saying, the state is now saying it simultaneously wants to pretend to have like the same identity of interest with this entity, that it gets a benefit from being separate from in a different context. And the Solicitor General is arguing you can't have it both ways.
Yeah, that's right.
More or less. Okay.
Yes.
All right, Jed. What do you make of all of this? Do you think that the Mohela standing argument is as weak as Persis appears to believe it is?
Let me put it this way: I don't think that Roberts and Kavanaugh care that much about what Persis and I think about.
Okay, wait.
Right?
What from the oral arguments gives you that impression?
Is that fair? I mean, what gives me that impression? I think the five conservatives are fired up for their own right-wing ideological reasons to get to the merits of this case, which are not their goals are not the same as my goals, and why I filed this brief. But they are for right-wing reasons. They want to get to the merits, and there is enough. I mean, Persis, I think you might agree that like there is at least a plausible factual basis for the fact that Missouri is, even if it takes a bunch of steps, that Missouri is on the hook for the losses if the losses accumulate to Mohela. Is that fair?
I mean, I don't think that is. I don't think that's accurate, and I think we even heard, the Nebraska Solicitor General agree, right? That
he was, first of all, he was a moron. I mean, he was as good as Preligar was. He should have pleaded the Fifth Amendment and just sat down. It would have been better. He was a disaster, but he was a disaster on every question he was asked. So I'm not gonna suggest that we learned anything one way or the other from him. Although he did. One of the justices had a whopper. I mean, in favor of what your conclusion is. One of the justices quoted a Missouri Supreme Court case where it said there was a kind of a similar agency, not Mohela, but something parallel to Mohela. And the Missouri Supreme Court said that this agency did not have the same identity of interests as the state of Michigan.
Right, and didn't they say it would be, and someone opined, and wasn't it a conservative justice who opined that it would be kind of odd for the Supreme Court to take a different position on this kind of state issue than the state court had taken?
It was, having not read that case and hearing it, it sounded like a big deal. And at the same time, Roberts and Kavanaugh did not seem all that troubled by it, which is telling. And so I think, my read is that Amy Coney Barrett is trying to get this right as a matter of law. And I did not hear the other 5 justices with the same angst about the process here. Now, I think Persis is right that this is a lot weaker than I had expected in reading the briefs. And so I'm not sure what's going to happen at all. But I would say a lot of commentators who heard the oral argument this is the reaction that I posted in real time, and that I thought it'd be 5 to 1 to 3, that it'd be 5 justices ruling on the merits, finding standing, and Amy Coney Barrett saying there's no standing, and the 3 on the left ruling in favor.
So Jed, as incompetent as this Nebraska AG maybe
sorry
is,
to be so mean about it, but
yeah, at the end of the day, these 5 justices that you're imagining are going to rule against Biden's debt cancellation plan still have to come up with their own argument as to why they think they're standing. So what do you imagine they're going to say to justify a holding in favor of these states?
I think there's enough. I think as just as a matter of, if you're looking for standing, the fact that Missouri is on the hook for losses to Mohela, it does. I mean, Persis is right.
Is it? I thought there was a whole argument about how there was no commingling.
Well, and that was the thing, right? Like they have like legally insulated themselves from any damages to Mohela, and again, like whatever we think about the performance of the Nebraska SG, right? Like he said on the record that in order for Missouri to absorb their assets or their losses, the legislature would have to come in and change the law. Right. And so like you would have to come, you would have to do something. And they're talking on like sovereign immunity grounds, right? Or not sovereign immunity, sorry. Eminent domain grounds, right? So like, is there a way in which like, sure, but again, there's lots of different steps, and there's lots of like political things or things by the Missouri State Legislature that would have to happen in order for that to be true. And so I think, could politics win? Maybe, but like, but I think on the law, I think we're shocked? Pretty good.
I mean, I don't know. I mean, the bottom line is, one of the problems is the lightning docket or the shadow docket. Like one person's thing that you said early on is exactly right. There is not enough of a record here where the actual parties demonstrated any of these facts in a district court. And we're just sort of, I think all of us are sort of grasping at comments and, oral argument statements that we shouldn't be relying on.
So why is that? What happened here? How did this rocket?
I was surprised. I thought that the Roberts Court would have been very happy for this to have played out and like let string out a nationwide injunction. I thought that they would wait until the next term to take this case and then strike it down in June of 2024, because that would have caused the most political damage by moving so quickly. In some ways, like they're actually giving the Biden administration one last possible chance to fix it. But what happened here is what the Roberts Court has done over and over again, which is grab cases, like nationwide injunction happens. There's not a full trial. The Fifth Circuit right-wing ideologues just rubber stamp it. And then the Roberts Court takes it and there's not enough factual basis or time to deliberate. And then you get sloppy ideological opinions. I mean, and this is the way it's going to be for the rest of our lives.
I think,
right?
Yeah, and I think one of the things, just to kind of like pick up on that, it is incredibly frustrating, right? Like I'm not like a Supreme Court watcher. Like I'm a student loan lawyer, right? And so I think it is incredibly frustrating from my perspective that there is that this lack of record it has the potential to, deny relief to tens of millions of people, and that is absolutely just, an atrocity.
It's appalling. Yeah.
It is absolutely appalling because it is 40 million people who are not going to get relief that the Department of Education, in its expert judgment, has determined they need. And because of a record that is incredibly flawed, like I said, I think it is incredible, I think the base question, right? Think about these states who have said, oh, we're going to lose money because of our FFEL portfolios. Well, actually, some investment firms have actually projected that cancellation would make these companies money, right? Mm-hmm. Because, these FFEL loans, they're old. They don't have great repayment. So somebody paying off their loans with the consolidation actually would benefit them because it'd be a more stable form of payment, right? The Mohela, their contract ends at the end of this year. Maybe they're, by the time that cancellation actually goes through, maybe the portfolio will be smaller, but maybe Mohela is not entitled to that contract anyway. So, I think there's a lot of different places where, if cancellation is denied, it is going to deny a lot of people relief that they really need based upon really imagined facts, and that's incredibly frustrating.
I agree, but no one is bathing themselves in glory in this story, right? So first of all, where is Mohela, and why is the Missouri SG not there to answer these questions?
That was such a big question in the context.
I think a lot of folks had a big question about that. Why? First, right, Missouri's not the one making the argument. But and then even if it were Missouri, it wouldn't be Mohela, right?
Totally. And Mohela refuses to participate in litigation. So These are reasons why, I'm not sure what's going to happen. Roberts and Kavanaugh seem, they could be persuadable that this case is too weird. But let's talk about who else is not bathed in glory here. The fact is that the Biden administration, late in the game, they announced this policy, and as I talked to both publicly and privately, I talked to lots of Persis, probably people you talk to too, and they acknowledge that even if it's likely that the Roberts Court strike it down, no one's going to have standing, they said, and they didn't know enough about the way that the student debts work, because a lot of these federal debts get outsourced to private companies, and it turns out a lot of private companies would have standing, and the Biden administration. And this is NPR. This is not Fox News. NPR had sources that said the reason why the Biden administration created an arbitrary line that they never gave a reason for excluding the debts held by outsourced to private companies was to dodge standing. And so there were 2 million debtors who either had their debts put back on that didn't get relief or got less relief because the Biden administration was dodging standing and dodging the rule of law. Now, we might not like what the courts would say, but it is also appalling that instead of trying to get it right, and instead of delivering more relief to more people, the Biden administration incompetently designed this program with terrible legal arguments. And then when they were caught with bad assumptions about standing and bad arguments, instead of fixing them, they denied more relief to more people.
But Jed, isn't your argument, your argument is kind of that even if you agree with us that this is not the greatest standing case that's been made, that because of politics, 5 justices are likely to reject Biden's student debt program anyway. But what are you arguing here? That if they, I'm generally sympathetic to the beat up on Biden and that he could have done this better. But are you really arguing that if they had done this the quote unquote right way, that there wouldn't be the same kind of legal challenge over standing? Just because how are they going to design it so that ultimately these lenders weren't able to bring a claim anyway?
And I think this is where it's helpful to think about the context that there were a lot of cases brought, right? This was a very concerted effort by a lot of right-wing organizations and political entities, and they brought a lot of cases, and it was kind of throw the spaghetti against the wall and see what sticks. See which case is going to find the judge that's going to be sympathetic to you, right? It's, I think that there's, I completely agree that had they done it any other way, I don't know that we would see a different result. I actually, I was really pleased with the analysis that the secretary came out with when they put out their Heroes Authority. I thought they did a very thorough analysis of the economics of, the looking at the historical data around default rates and delinquencies following other similar types of emergencies, So I was actually really pleased. I thought they made a really excellent case for the use of hero's authority. I don't disagree that they could have done it a different way, but I think that the path that they did ultimately choose, I think it was viable. And I don't know that we would be in a different.
Wait, did you hear this? Any of the 6 justices persuaded by those arguments?
Well, here's the thing: is I think that those were very politically driven.
No, it's clearly
questions.
a loser. Let's be honest.
And I don't know that, but I don't know that if we had done it under settlement and compromise, we'd never necessarily be in a different place. And I think that what they object to is the politics of it. They object to giving debt cancellation to 40 million people, and so they're looking for arguments.
But in fairness, I mean, the idea, the optics, if we are all understanding that this is being viewed through a political lens, the court's legitimate, perhaps we think that we're so far gone that the court can do whatever it wants, no rule of law, blah, blah, blah. But if we think there's at least some sense that if there were a horde of 1 million people outside of the Supreme Court because people were so angry because what they did was so flagrant that it would start to affect their decision-making in a kind of post-New Deal sort of a way. Like the people's will is going to just rise up and impose itself onto the court. Like, if they are able to plausibly say, Joe Biden just said COVID's over, and now here he is saying that he wants to use basically COVID emergency authority as a hook for student debt cancellation. Obviously, this isn't going to fly. I think there's a real case for there being much less political outrage than if they say, here is a Higher Education Act, which specifically provides for exactly this kind of action, canceling student debt. Joe Biden, this is not, executive fiat. There's legislation that explicitly is on point here. Why Joe Biden tried this? Now, if they overturn that and said Joe Biden didn't have authority that way, then there'd be a more grist for public outrage in a way that might incentivize them. Yeah, go ahead.
Yeah, so I think there's a number of different places, right, where I think this this line of reasoning falls apart. I think first of all, debt cancellation period is pretty popular, and even in the polling that we've done, even amongst young Republicans, debt cancellation is actually really popular. So I think that the public is really angry about Biden doing this, I don't think is actually materialized. I think there are some vocal people who are opposed to it, but I think on the whole, actually, the populace is actually in support of it.
No, I agree with that. What I'm saying is that the public is basically, look, the public loves Medicare for all too, but everyone's sitting around alone in their home, ashamed of the fact that they can't afford healthcare for their families. And until there's some organizing principle that says, hey, you're actually allowed to be mad at this. This is a systemic issue, not a personal failing. You don't get the kind of public outrage that I think can start to move people politically, right? And that's my concern, that if people feel like, well, I didn't really deserve this because the case wasn't that good, you're not going to get the kind of political blowback that could force people to act appropriately, from my view, in this situation.
So, go ahead.
Well, I want Persis to go ahead and finish that thought because I interrupted her. Go ahead. I'm sorry.
Okay. So, I think, I guess I'll start, the next place, so we have the politics of the people, and then you have the politics of the politicians, right? And I think that's what's really driving this case, right? Is the politics of the groups who are going to hate what Biden does because Biden does it, not because of what law he uses or how he does it or why he does it or when he does it, right? It is that level of politics that is driving this case. And I think that is pretty nakedly obvious from the cases that are before the court now, right? You have the case, with the 2 borrowers. It's not 2 borrowers who just were really jazzed up about and about the right to notice and comment, right? This was the Jobs Creator Network who very aggressively, not happened to wander upon a couple borrowers who didn't qualify for loan cancellation. They very aggressively had a campaign to recruit as many borrowers as they could find, and they only came up with 2, right? And so this is entirely about politics and entirely about opposing whatever Joe Biden is going to do. And I think it would, no matter what authority he used, we would have seen the same kind of vitriol against the policy. And then we've been in a student loan payment pause for, looking at the calendar, just under 3 years now, right? And that's real. And I think the piece. I think borrowers understand why this is pandemic related. We filed an amicus brief too. We filed a brief It was supported by over 50 legal services organizations and a couple dozen more borrower advocacy organizations. And it is because like borrowers really are still suffering the consequences of COVID. And I think, when we did our polling as to whether or not people support cancellation, I think borrowers certainly understand that, but also people who've paid off their loans understand that. People who live next door to borrowers understand that. And so the impact of the pandemic is still impacting student loan borrowers. Student loan borrowers are not, as Robert suggested, all people who went to four-year colleges, got their degrees, and are now working very lucrative jobs. Almost half of borrowers did not complete their degrees. A large number of people who maybe completed, it's not a 4-year or a master's or a law degree, for example, and so student loan debt is in fact impacting a lot of folks who are lower income, who are women, who are people of color, whose lives have been seriously disrupted by the pandemic and who have not recovered, right? Like we highlighted the stories of folks who had businesses that have not recovered from the pandemic. We highlighted this, the stories. I mean, Jed, you're a parent too, right? Like we know how hard that was to work. And I have the benefit, I'm here in my home office. And so that worked out okay in the end, but
my whiteboard that I use with my kids, right? Yeah.
But a lot of I had a lot of clients that I worked with who could not, the choice was care for their children or work. And so a lot of people lost their jobs, and recovering from that takes time. We may not be, right? This is not the same thing as the border wall where we're concerned about the transmission of the virus anymore, right? We're talking about the economic fallout of the pandemic, and the economic fallout takes longer to recover. And that is just the reality. And I think that on the ground, real people understand that reality.
Unfortunately, I wish the ground were the Supreme Court's floor, but unfortunately those are two very different political spaces. And I want to come back to you, Jed, because you, of course, wrote an amicus brief as well, one that was referenced by, it was Justice Roberts during the oral arguments.
Kavanaugh.
It was Kavanaugh. Sorry, it was Kavanaugh.
Yeah.
During the arguments yesterday, and I know people were
makes me feel even better. But,
people were up in arms about this. Some people have been frustrated about the posture that you've taken throughout this whole Michigas shenanigans, whatever.
Yes.
So what did you say that in your amicus brief? What was the point of your amicus brief, and why was it cited by a conservative justice yesterday?
Yes, and what Persis is saying is really important about the, and I think what she's talking about is big picture. There is a massive structural problem with education finance, with or without pandemics, right? The programs that Persis the problems that she's talking about are true with before, during, and after the pandemic. And so I just want to, before I talk about the legal question and really about the abuse of emergency power, because I'm writing this brief not because I'm particularly fired up again. I mean, I support student debt waiver, and I support it for structural reasons, and I support it from the Higher Education Act as a precedent for more. So one question I have is, but lots of student debt advocates say, it's a real shame that they didn't use this moment with the Biden administration to go back to the real answer and the long-term answer of the Higher Education Act. What people talk about behind closed doors? The fact that they used the Emergency Act was not just the most convenient way to get it through, but it was also a convenient signal to Wall Street that this was going to be a ticket for one and only one debt relief, and no precedent for the structural harm. Just as long as there's a pandemic, we're going to give you a cookie. And this is, and it's not just the Biden administration. The background is Bill Clinton signed a statute that created negotiated regulation that makes it harder to do this. So that is the Clinton Wall Street wing of the party. Then Obama issues regulations under the Higher Education Act that says it has to be case by case. That's why you have to rescind these regulations, is because the Obama Wall Street wing of the party wants to send signals to Wall Street and banks. Don't worry, we're not going to go Bernie on you. And then Biden comes along and says, it's a nice Higher Education Act, but the emergency is a way for us to be clear. We're not going Bernie. We're not going Elizabeth Warren. We're going to make it safe. We're going to make sure that banks know how safe they are, that this is just on the last days of COVID. And in fact, they couldn't even get it in the last days of COVID, because then the second point is, Brianna, this show is called, your podcast is about bad faith. this is the topic for today, is the bad faith of the Biden administration. That you wait, what happened? They waited until Joe Manchin and Kristen Sinema finally agreed and passed the Build Back Better, changed the name to the Inflation Reduction Act. And so they needed to get something out fast in time for the November election to get young people fired up. And they regarded it as a win-win. They regarded it, if they can get it through, and they didn't really think they were going to get it through. If they lose, they can blame it on the 6-3 Roberts Court. And in bad faith, they can blame the Supreme Court, where there's enough reason to get pissed off at the Roberts Court. How about just Roe v. Wade and Dobbs? Like, anything else is a distraction from that. But you know what else is a distraction? Is setting up a loser case that then lots of people say, well, maybe the Roberts Court isn't so bad, because the Biden administration comes forward, they announced this policy in August, and 3 weeks later, Biden says on 60 Minutes, the pandemic, the emergency is over. It's really hard to talk about this emergency policy if just before the policy is announced to say the pandemic's over. And then in January, Biden says we're extending the emergency declaration to May. Why? He says to the press in public, it's because we still have stuff to get done. Never let a crisis go to waste. Everyone knows it doesn't pass the smell test. Everyone knows that the goal here was, rightly, structural problems, broad waiver. And the reliance on an emergency is, A, in bad faith, and 2, it's a bad precedent. Because we just lived through 4 years of an authoritarian president abusing emergency powers to ban the Muslim ban, shifting money for a bogus border wall, putting kids in cages and family separation. The reason why I wrote this brief is that we've seen this movie before. We know how democracies end. And this might seem like a very minor case, but a major case for debt relief, but a minor abuse of emergency powers. The Biden administration has just established another precedent for Republicans to use as an excuse when they want to use the next emergency for a much more damaging.
Okay, Jed, I hear this, but here's the counter argument. The outcome of this case is not going to determine whether or not emergency powers are restrained in any way, shape, or form. That we have all acknowledged that this is a political environment, this is a political court, and Republicans have never shown any restraint when they're trying to enact their powers. All of the emergency actions that Trump implemented or attempted to implement that you just laid out happened and will continue to happen if Trump or whomever is president next time around.
I'm not sure that's right. But Brianna, we just saw some of the examples I gave you were pushback against the Trump administration. That's
why I said enacted or attempted to enact. So some of them there was pushback. We didn't have, ultimately Trump put his foot in his mouth and said, hey, I love banning Muslims because they're Muslim, and therefore the Muslim ban fell through. Go ahead, Persis.
Yeah, I mean, there's so much to react in all of that. But I mean, I think, starting at the end and then working our way forward, I mean, I think you can draw a distinction. I mean, first of all, some of these were manufactured emergencies. COVID is not a manufactured emergency. It is a real thing that impacted all.
I'm sorry. Biden says it's over. I mean, that's I understand what you're saying, but but be responsive to my argument.
No. So here's the thing.
It's a real emergency.
But it's different. It is materially different to say that we are no longer living in fear. And actually, that is not even exactly what he's saying when he ended the national emergency. He was more like, it's not that we're not living in fear of transmission of the virus, but it's that, we just have to at some point figure out how to move on with our lives, and not have so it's but the national emergency is about the transmission of the virus. And what the HEROES Act is about the economic fallout from the national emergency. And I think that it is not the same thing, right? You can say that I no longer, fear the virus when I walk into CVS, but that doesn't mean that my job came back. That doesn't mean that, that my business came back, right? It doesn't mean, and that these payments that I haven't made, that they can suddenly be cascading back at me without any kind of, financial consequence to me when that happens. And so certainly, I think they're obviously connected, but there was a national emergency. It caused massive disruption, and we have not yet dug out from that. And I think the fact that we're still in a payment pause, and I mean, I think that the cancellation is part of that effort to get out of this payment pause, right? The cancellation, what they're trying to do is that they are trying to end the national emergency. They're trying to get back to repayment. And the way that they think that they can do that is through cancellation, that you can't just turn payment. You can't just turn off a switch and turn it back on.
You could stage it. You could make it. You could extend.
Now we're talking about second guessing the secretary in the way that they do a thing. But we're still talking about doing a thing, right? We're still talking about doing a thing under the hero's authority in order to mitigate, the financial harm caused by a national emergency. So if you wanted to structure it differently, then you could have, but but you're still using the same authority.
So the statute says that it's not just that an emergency opens all these doors. So the first paragraph of that section of the statute says it's for a war, a military operation, or an emergency. The word emergency is fine. I agree with you that, of course, COVID was an emergency. The next paragraph says that it talks about the affected individuals, and it has to be that those are not, so that they're not worse off. They're not put in a worse financial position because of the emergency. And so the argument is, and look, I grant that this is the argument. This is what they put to the court, is that because they're after pauses and moratoria, there is a pattern of defaults. But the problem is, first of all, that there was nothing in the design of the program that identified who was, there are some people who were made better off because of the nature of the markets during the pandemic. I'm not saying how many, but there were lots of people who did, between PPP loans or the fact that they worked for Pfizer or in remote learning. I mean, there are lots of people who the economy was not much worse.
There might be someone who's better off after 9/11 because they got their competitor was in the twat tower that went down.
Also, that's not the standard of which the HEROES Act has been applied, right? That's the other thing, is that it has not been applied about individuals, right? The payment suspension has been all borrowers, and just to point to your language a little bit, it takes actions necessary to ensure that any individual is not harmed, right? And so in order to ensure means that you can be over inclusive of the relief. You don't have to be individually targeted. And as somebody who has represented student loan borrowers for over a decade, I can tell you that you have to do things overbroad if you want to reach them. I wrote an op-ed with a disability advocate about how targeted, frankly, it's more targeted than I would like even to begin with. But, the more targeted you make relief, the more likely you are to make it. The people who need it the most do not get it. So if you want to take steps to ensure that borrowers who need this and are going to be in a worse financial position because of the pandemic, you have to be overbroad. It's just the way ask any public benefits, provider in this country. If you don't give it broadly, you're not going to get it to the people who need it.
So, Jed, what do you make of that? This argument that you're kind of talking about how, well, you could extend the loan pause, which is under the same authority as the HEROES Act, and ostensibly has all the same concerns that you are bringing up about the HEROES Act language. But that ultimately, and this obviously was a subject of oral arguments, there was a lot of discussion about whether the language of waive or modify encompass what we're...
Right, I know, yeah. That's a problem, is that if you look at, if you put the whole statute together and not just grab the word emergency, then there are several problems with it. One is that the modify or waive. Now, look, there's a lot to be made of the word modify being moderate, but then Congress added the word waive, right? Except that it's modify or waive a provision or regulation.
Even Kavanaugh seemed open to that, right? There was that clip where was it Kavanaugh? I think it was Kavanaugh, right? Or maybe it was Roberts.
I didn't hear a lot of, I heard openness to the fact that it was waive as a broader word, but if we get into statutory interpretation, there are problems with the text being read as broadly as it is here, but especially in the context of, this is what the major question doctrine is about, is asking about the purposes. And it's really hard when the statute leads with these 6 purposes or findings, and they're about the active service, active duty military. It's all about the active nature of the emergency is the purpose of the
But Jed, are we now getting into reading the tea leaves? It seems like this is the argument that liberals are making and that people on the left are making, that it's about strict language on the page when it comes to conservatives wanting to limit rights. Suddenly, when the language is pretty clear that words mean what words mean, you're allowed to waive student loans in this case. You're allowed to modify and waive. Waive is very expansive. People have had a really hard time arguing that waive is limited. that suddenly it's like, well, the purpose of the bill and the other context.
And can we just like also point, I mean, and like, I know that like, we don't think that Kagan's word is going to win the day here, but I think Kagan put it perfectly, right? You know, when she said, we deal with congressional statutes every day that are really confusing. This is not one of them.
Yes.
So, you know, Congress could not have made this much more clear. I mean, Congress didn't say exactly the circumstances in which it wanted the Secretary to use this authority. Of course not. This is a bill about, like, what happens when you have an emergency. So what Congress said is what happens when you have an emergency is the Secretary has the power to take care of emergencies. And it has that power by way of waiving or modifying any provision and adding others in lieu of them.
A couple of responses. The adding in lieu of language, that has to be understood to mean adding along the lines of a modification. It can't be adding just anything the Secretary wants. It has to be read in context with the terms
or a waiver,
or modify.
Or, and, you know, it's not just modify, it's waive. So it's modify, even if we take a kind of MCI type reading of modify, all, you know, through more major changes all the way up to waive. And then you can say what terms and conditions should be applied in lieu of those provisions. Congress doesn't get much clearer than that. We deal with congressional statutes every day that are really confusing. This one is not.
Right, like those were her words. That the statute. I mean, I think this is the other piece, and like,
wait. After this conversation, you think that you think it's obvious? You think the statute is clear?
I mean, I think that we're lawyers and we can twist words in many different ways to make people confused. But I think I do think the language is clear. And I think the other piece, in terms of like, does waive and modify encompass like cancellation, right? Like, canceling debt is a thing that like the Secretary does all the time. It's a very normal part of the Higher Education Act. It's a very normal part of like finance in general. Like,
wait. You just said it's a very, okay, hold on a second. You said it's a very normal part of the Higher Education Act. So,
yeah, absolutely, right? Because we're modifying any statute or regulation or provision of the Higher Education Act, right? And so, like, it can't be extraordinary and normal simultaneously.
But Persis, he's making now the case that they should have used the Higher Education Act then, because we're actually in the HEROES Act.
But here's the thing: because they had a different set of authorities, doesn't mean that they couldn't have used this set of authorities.
Except,
right?
Well,
but they did.
That is how statutory interpretation works. And one of the arguments that, I mean, it wasn't a great oral argument overall, but one thing the Nebraska Solicitor General said is when Congress does the thing that you just mentioned, like in the Higher Education Act, there are a set of words they use. And, and those words, as you know, are much clearer about waiving the obligations as opposed to the language used in the HEROES Act. And that's called the whole code canon, is where you say canon, Congress writes from a background. And frankly, Persis, it's exactly what you just said. This is a normal thing that Congress delegates in a normal way with specific words, and those are not the words in the HEROES Act. But I don't want to get, like, that's actually not my thing.
What I'm trying to say, though, what I'm trying to say is that when we're talking about relief, right, like they talk about cancellation as this extraordinary measure. And when we're talking about a relief measure, right, like we have the disability discharge program, right, which is a program that says if people are, have disabilities that prevent them from being able to work, we have this discharge program that helps them financially. We have the closed school, we have the borrower defense, we have a number of different provisions to provide debt relief to folks by canceling their loans in times of when we presume there to be some kind of financial harm. And it's normal across the financial spectrum as well. It is a tool in your toolbox when you're trying to provide relief to consumers with financial products. And so, like, to say that it is somehow extraordinary that people are using cancellation as one of the tools, that like somehow waive and modify could obviously mean deferment or forbearance, but it couldn't possibly mean cancellation. I think it just is a little like
I think that's the point right there at the end. Like, firmly within the realm of the HEROES Act. The whole point of the HEROES Act is that it is relatively rare. It's emergency authority. So the fact that everyone is very comfortable with Donald Trump using emergency authority to postpone these loans in the first place, how do you get to a place where you're basically not having a legal challenge to that, raise no concerns about that, and are suddenly going to say that that's applicable, that the statute applies to that kind of relief and it doesn't apply to the student debt cancellation? That's why we ended up, right, with the whole colloquy about waive and modify, and whether, that's how we ended up there. And staying there, I just don't see how you distinguish it and how you can say, in the context of the HEROES Act, which we've already basically acknowledged can be used to at very least suspend student debt payments, that waive and modify doesn't cover just waiving the debt, literally just waiving the debt.
Well, first, so again, there is a difference of degree versus a difference of kind. So extending, I think we can agree that pausing or a moratorium is a time period, and that is modify, and that's modifying provisions. Again, I'm going back to the language of the statute, and again, this is not the thing that I'm focused on. In my, I just want to be clear. Like if this is not why I wrote the brief, was because I wanted to have a narrow construction of waivers. It was in some ways it's precisely because I agree with Persis that the Higher Education Act has that language and is the appropriate measure.
But wait a minute, the HEROES Act is what we're talking about right now, Jed, that has that language. It has the waive language in it.
But it has a modify or waive a provision or regulation, which is not the formula, and I think Persis would acknowledge that this is what came out in the oral argument. Is that you would agree, right? You'd agree.
No,
that,
I mean, I thought he had an excellent, right? Like, here's the thing. We have a whole lot of provisions that are available in order to cancel loans. What we need to do is we need to waive and modify some of the requirements for those provisions in order to provide them to the borrowers, right?
So, yes. And we have others. Congress has delegated that authority with a set of words that are clearer. And when Congress wanted to enable that broad waiving of the obligation, it used those language But
Jed, it waived the obligation for the last 3 years.
That's not what waiver is. I mean, Persis would agree with this. That's not a waiver.
Modify the obligation.
They did, right? Like, there are people who haven't been accruing interest, so they've waived that, right? So
but that's not waive. Come on. That's not waiving.
Wait, how is that not waiver? I feel like my student loan debts have been waived for the last 3 years. It's been a real boon for me.
Can we just take a step back?
Here's the thing. People talk about the cost. The cost of the payment pause is frankly more than, of the cancellation.
I'm talking about the difference of kind between the moratorium of delaying payments, but the principle still sits.
Where is that in the language, Jed?
I agree. I think that's reading way more into the words that actually exist.
We can agree to disagree about that.
Let's hear. I want to hear this, because what's the argument for where in the HEROES Act is there language that suggests to you that a moratorium on student debt is different in kind in a way that is legislatively significant from a cancellation or waiver of the debt in its entirety?
Well, I'll go back and say it. I just feel like I'm repeating myself now, but because what came out and clearly an oral argument, and Preligard didn't have a great response to this, is that there are, again, the phrase modify or waive is not by itself. It modify or waive, and it has a more limited sense of words about the provisions that relate to the regulations, as opposed to now. So this is
statutory or regulatory provision. That is not a limiting factor. That is quite a broad phrase that comes right after waiver modify.
Okay, so it also is the context. I'm repeating myself again, but part of what happens with the major question doctrine is that you look at the purpose of the statute and the context and the focus on active duty or active service and an active emergency, and the argument that is made, you go to war with the army you have and not the army you wish you have. You go to war with the statutes, and you go to policy with the statute you have and you have the arguments that the Department of Education made. They rested on this argument about there was the COVID, then there was, and the causal link they make is indirect to COVID, indirect to the emergency. It's about the waivers and the modifications of delay, pause, moratorium. And that's an indirect point. But here, look, I really want to get back to this is why I wrote this brief. And I hope we can at least acknowledge that this is a significant issue, is that look, everyone knows that the point here and the way the program was designed was a way to get to broad waiver. Was finding a way from the commitment and the campaigns of 2020 to then have a broad structural program, and that broad waiver of every, without any policy in the program that requires any correlation to COVID, was out of a pretext. The emergency was a pretext here, and I think the reason why they used it was because there was also a political purpose here. It was a political purpose to be able to wait until after the statutes were passed and be able to announce something just in time before the November election for political points.
I think that's probably
and
true.
I think that's a significant problem as a precedent if we're talking about.
But that's a political question, and we've talked about that.
No,
Jed,
I'm sorry, it's not a political question. It's a legal question.
I don't think that's. I'm minimizing in the least. I think it's very important. We talked about this on this show. I've talked about it on Rising, how I think the timing of this was extremely suspicious. I think that Biden's choice not to just cancel all student debt on day one basically set us up for this conflict, because if he just canceled it without means testing it, we wouldn't have had an opportunity for all of these, conservatives to gin up these plaintiffs out of nowhere that are so absurd and bring these legal challenges in the first place. And now we would be in the posture of these right-wingers trying to figure out how to force money back onto people's student loan balances, which would be an impossible task. So I agree with you on that political question. But here in the context of this legal argument, and I also take your point, Jed, that because of the politics of the Supreme Court, even if you make the best legal argument right now here on this podcast, and as good as the Solicitor General was, it's very likely that the Biden administration is going to lose this one. I take all of those points. But for just us here in this safe space, I'm really struggling with the distinctions, like with the argument that this is actually not a viable legal case. I agree with you that there were many better cases that could potentially have been made, and that maybe Joe Biden intentionally didn't make the best one. But as I'm hearing Persis argue, and as I listened to the pieces of the oral argument yesterday that I was able to listen to, I was increasingly convinced that if this were any other context, even with a weighted politics against us, the case is still pretty good that on the pure language of the HEROES Act, they should be able to grant this relief.
Yeah, and I think that's right. I mean, I think, on the major questions doctrine, right? Like, it's reserved for agency actions which are, with tenuous legal authority, right? So like, can you
just explain what I wanted to talk about this, but for those folks who don't know what the major questions doctrine is and why it's kind of like controversial.
You want me to jump? I can give
go ahead.
I teach administrative law, and I was actually just teaching this today.
Oh, I'm sorry. I definitely did not sleep through my administrative law class. It was very stimulating. I loved learning all about it.
We talk about immigration and all the ways that it ties into race and sex and sexual orientation is literally the bread and butter of this class.
Well, maybe yours was sexier than mine.
But that's So here's a key thing about the major question doctrine is to separate out how crazy right wing it's gotten in the past year versus where it started. And so one example is that Roberts and Kennedy ruled with the liberals to save one of the huge pieces of the ACA, Obamacare, by reading the purpose of the statute and not just focusing on a word. That word was state. It was a mistake that was left in the statute. And the word state related to was about exchanges. And Obamacare needed Obama created federal exchanges when the limit was and used tax credits there. The word state does not include federal. And the Roberts for a 6-3 majority said, we're not, and I'm here all day for the rejection of textualism. They said, if it's a big deal, don't be like Scalia and obsessed with one word out of context. Look at the purpose. And liberals thought that was great, right? So I did. And the second point was, don't defer to the executive branch. This is what the word means. And so Republicans can't change it because there has deference to every new administration. It's now frozen. As allowing federal exchanges. So the major question doctrine has some important background to it. So then when it comes up in this case, there is a bad major question doctrine strand that's come out in the last year or so, striking down a climate change proposal for a ridiculous twist or ridiculous right-wing version. But if we go back to the common sense major question doctrine, the point is you don't just look at the word emergency and say, great. Like, that's the point that I wrote this brief for, which is right-wingers look at we've seen this movie before, and it's, and it's even worse in German, that movie. Like, that movie is the use and abuse of emergency powers, and for ways that centralize or concentrate powers for pretexts. And the point of the brief is to say, of course, we need to have emergency powers granted to the executive branch. But the way to limit those emergency powers from either, overreactions or pretextual abuses is to make sure that the policies line up in good faith, that the means relate to the ends. And
so
that's
Persis,
right. So go ahead.
Yeah. So what were you going to say about the major questions doctrine?
Yeah. So so here's the thing. I think the piece that got missed here is it's got to be more than just a big deal, right? Like, of course it's a big deal, but the whole pandemic was a big deal, right? And the student loan system, right? It's a $1.7 trillion atrocity, as Jed has said. It is, there are a lot of problems. I am the first one to tell you, it's usually my first talking point about how broken the student loan system is. But I think the piece is right, like, it has to both be like tenuous legal authority. We have very clear legal authority with very clear boundaries about it has to be connected to the national emergency. It has to be using to waive or modify provisions of the Higher Education Act, which we agree that there are provisions of the Higher Education Act that allow cancellation. And so it has to be extraordinary and unheralded, right? Like, we've had this payment pause. We've had other cancellation. It's not extraordinary and unheralded, right? Like, it's big and it's like important. But I think more importantly, like, it is also pandemic related, right? Like, the campaign promises happened in the context of a pandemic. And, as somebody who has been pushing for cancellation for the past 3 years, part of the explanation is that payment pauses just kick the can down the road, right? Like, we just gave cash to other people. We just made payments for other people. Instead, student loan borrowers were put in this kind of like tenuous, like, limbo state, which was just kicking the can down the road, and we're at the end of the road, right? Like, cancellation has always been the answer about the pandemic.
Just to back it up just a little bit for people. So you're saying that there's the major questions doctrine, as it's being arguably triggered by more conservative leaning people in the courts in this moment, is to say, even if the text as we read it exactly might allow this was obviously not the bigger goal here of the act. And so in this case, it would have a conservative leading outcome. So you're arguing, you're looking at the elements of when something actually should have the major questions doctrine applied. And you're saying it's not just that something is big. It can't just be that it's a big issue, but it has to have some of these other elements going on that you don't think factor in here, that aren't at play here with the student debt context.
I think that's right. And I think the other piece, but I think the connection to the pandemic, but I think also the pandemic is important to recognize here, right? And I think that piece.
Well, you're conflating what makes something a major question doctrine, and then if it's a major question doctrine, then what are the steps that follow?
So, Jed, do you think that this is an appropriate context to be bringing in the major question doctrine?
I mean, let me put it this way. I don't actually care that much about the major question doctrine to get to these two steps. I'm not a textualist. I think Scalia's textualism was an ideological framework. So what the major question doctrine gives us, I want anyway for all cases, which is, one, get away from silly textualism, like get away from word games. Like that's Scalia's big thing. I would never bought into that. So I'm not a textualist. So good. If the major question doctrine gets us away from silly word games, or gets us away from the word state having to be frozen as the word state, either way, that's fine with me. So that's one thing. And the second is, I don't think Chevron makes a ton of sense for reasons that are for a different class.
Jed,
at a different
don't
time.
make me make you explain
Sorry,
Chevron to this audience. They've been
we don't
through
have
enough.
time for Chevron,
Okay.
But the point is, but here's what the court told us, and I think it's valid. I mean, I think Prelogar did a good job by saying it's a major question doctrine is major if it affects people, if it limits people's liberty interests. And the answer from the court, which is important, is that the major question doctrine also is about separation of powers values and about limiting really what that's about.
But I think here's the thing, and so and then even if we get through all of that, Congress conferred this authority to the secretary in relationship to these to a national emergency. And we have that here. And if you look at the data, you look at the economic data of like the borrowers whose loans were not paused and the borrowers whose loans were paused, right? Like we know that there is still financial distress from the fallout of the pandemic. And so so however we get there, the use of the authority was still appropriate, right? It's still within the connection to the national emergency. So this is not the same thing as like, ginning up a national emergency in order to build a border wall, right? And certainly I think we have a better connection, and I think the secretary laid out a much better connection about how this is related. So we're not necessarily like throwing an entire race of people in prison. So I think that there's real distinctions between the ways that that emergency authorities have been used before and how the secretary is using it in this case.
Well, but do you worry about? I worry about the bipartisan increase of executive power. Maybe this is a signal that let me put it this way. I think we've laid out the issues great.
I think
we now understand why this argument lasted some 4 hours.
I know.
This has been
totally
way richer than I even imagined. I'm so glad we were able to schedule this so that we had more than half an hour. I had a suspicion that it was going to take more than half an hour to get all of this out. So I'm so glad we were able to reschedule. Thank you so much, Jed, Persis. Would you like to tell people where to find you on the internet? I'll start with you, Persis. And anything else you've been writing or doing and all that?
Sure thing. You can find my organization, and then we put out many reports and blogs at protectborrowers.org. We also run the website cancellmystudentdebt.org as well, and where we give financial advice to student loan borrowers.
Terrific. And Jed, where can people find you on the internet?
I just want to say that if this is about student investment, I just want to say, Persis, you made a very good investment in your education in law school. You're a very good lawyer. I look forward to more conversations about that, and I'm happy to end with that note.
Thank you.
Okay, I love that. Thanks, guys. And thanks for listening to Bad Faith Podcast. Subscribers know you can get an extra episode every week on Mondays at patreon.com/badfaithpodcast. I hope you enjoyed this as much as I did. I'll see you later tonight on Colin. Keep the faith. Hey, YouTube. Thanks for watching. Just a reminder that this is a podcast. You can catch an extra premium episode every Monday for $5 a month at patreon.com/badfaithpodcast. That's patreon.com/badfaithpodcast for $5 a month, an extra episode every week. Additionally, please do consider liking this video, subscribing to this channel. It helps us out. It helps independent media beat the algorithm. We appreciate you. And as always, keep the faith.